Hi, it's Randy Herman, Associate Broker with Keller Williams Realty, bringing you Everything Real Estate, the show that answers all your real estate questions and interviews the top experts in the field of real estate. We've been talking about putting together your team, and one part of that team that I think is essential is having a trust and estates attorney. And I happen to have with me today the honor of speaking with Sean Hagan. Thanks, Sean, for coming.
Well, thank you for having me.
Yep. Really appreciate it. You know, real estate is such a big investment for people, and it's so important that they buy it under the right structure and that it's protected, and that's where you come in, right?
That's right. It's for most people, it's one of their largest assets, and a lot of people don't know what they can do and how they can actually save on state estate taxes and all these things. They can actually save money by setting it up in advance. So if you're doing all this work at the same time, you don't have to do multiple deeds and things like that. It's a much cleaner process for people, but it's not often brought up, unless someone like yourself that's knowledgeable about it is putting that on those people's radar.
So why don't we start off, and you can tell us a little about yourself, your background, and your company.
Sure. I'm a tax attorney by training. I went to Suffolk Law School here in Boston and then did the BU program after, and specifically to deal with estate planning, working with families and business owners, getting them set up with documents. The firm I'm at is Long Knight Huff Harrison Hagan. So we've got 3 other partners. We've got several associate attorneys, about 15 people, and we've got several offices throughout the Boston area. So Brookline, downtown at Lewis Wharf, and then out in Rosendale, which is one of my favorite neighborhoods in Boston.
Right.
So.
You also have a satellite office in New York,
We
right?
do, because we've got several cases down there. And so James, who's my partner, he's licensed in New York, so we've got several state matters down there as well.
Wonderful. So let's dig right in
here
and get right into it. So what is a will?
So a will, is the thing that people think of first when they think of estate planning.
Right.
But the modern estate plan really should include a revocable living trust as well. So the will itself, in general terms, decides who you're going to leave your assets to, and also appoints someone to be the executor of your estate, or what's now called a personal representative. But most modern estate plans would basically have the beneficiary of that will be their trust, because the will itself is publicly filed and it doesn't work until death, and a lot of other sort of negatives to only have a will. So people ask me all the time, is a will enough? Usually not, especially if you live here in the Commonwealth.
And the term you hear all the time is probate. What is probate?
The most expensive process? No. One of the more expensive components when someone passes away is the probate and estate administration that occurs. And this is the Commonwealth's process to make sure that the people that are supposed to receive assets do, on time. Creditors can make claims on the estate. And so by avoiding that process, you're really lowering your legal fees. And also, you're sort of taking assets that otherwise would be in the view of the public, out of view, and it's all dealt with on the trust side. And the way we avoid probate is to have the type of trust we've been discussing and make assets, instead of in your own name, in the name of that trust.
Maybe you can simplify it down, because
Sure.
so many people just don't understand it. What is the process actually that happens after someone dies?
So you have to file documents with the state, with the probate court, and you'll be filing a will if they have one. And if you don't have a will, you'll be under the state's intestate statute. So the default law, the state basically decides which family members are to receive your assets, and that's based on your family composition, and that's on the books as a statute. So you really want to avoid the state deciding, and that's why people do a will and a trust. And there's a petition. You have to go before the court and say, I want to be the personal representative or executor, and then the court has to approve you. And all that takes time. Then any assets that were in the decedent's name that were not in trust have to be sitting in an estate account for over a year. So it's really a cumbersome process, you might imagine.
And you can short circuit this
You
process?
can avoid it by having those assets placed in trust instead of in your own name.
I see.
Yeah.
Okay. So what do you actually do as a estates and trust attorney?
So some estate attorneys only do the drafting side. They're creating those documents that we're talking about. The will, the trust, powers of attorney, healthcare proxies. So sort of health and wealth decision-making documents, right? Granting people the authority to make these decisions and give them instructions. But my firm also handles the litigation that occurs when there's issues with this, and the probate and estate.
Can you give us a couple examples?
Absolutely. So, mom is up in age, there's 2 siblings, and mom changes her will because, the daughter has been taking care of her recently, and she wants to, benefit the daughter. A common thing would be to contest that will. Mom, wasn't of her right mind. She meant to split things equally. That's what she told me. So we get a lot of intra-family conflict over these different documents. So That's an example there. And then we also deal with the probate and estate administration, so that whole process, ferrying a client through that process with the Commonwealth that I mentioned before.
Right. And do you deal with taxes as well?
Of course, yep. So one of the biggest things is people think, all right, estate planning, high net worth, right? I'm not going to deal with estate taxes. My estate won't be that big. And that may be true for the federal estate tax, which is over $5 million per person right now, 5.49.
Right.
But here in Massachusetts, we've got a much lower threshold. It's only $1 million. So if you own a home, and as you know, the prices are just keep on going up right here.
Unbelievable.
So, right, absolutely. Chances are you're going to be subject to some state estate tax, and we can actually minimize that and make it tax efficient by doing a revocable living trust and creating a bypass trust.
Okay, and then do you deal with the representation of the trusts and estates? I mean, are you the representative, or is someone appointed? Or?
So we usually have a family member appointed for a estate when someone passes,
Right.
but I would be the drafting attorney or an associate on creating those documents in the first place.
I see.
Yes.
So let's take just a step back here
Sure.
for a second and just get to the real basics here. What is an estate?
So
And what is an estate plan?
Sure. So your estate is everything that you own or have a right to at your death. And so when we talk about an estate plan, we're not just focusing on death. We're also focusing on incapacity during life. So we're planning for these two sort of disaster events, which is why it's something a lot of people don't take care of right away. It's not a fun thing to sit around and say, all right, let's contemplate, death and taxes, right?
I've been meaning to do my estate for a long time now.
So it's that sort of dull, gnawing, to-do list item, right? And so we try and tell people what will happen if you don't get it done. And when they do come see us, they usually walk out relieved to know that they're going to be taken care of and that this is checked off.
Right.
Yeah.
And then a trust? What is a trust?
So a trust is a type of ownership. And what you're doing is you're actually separating legal and equitable title. That's sort of the legal component of it. But what it's effectively doing is a set of instructions, and you appoint a trustee. And usually you're in charge during your life. You're the trustee of your own trust. But then at either incapacity or at death, someone else steps in. Be that it could be a spouse that steps in, that's typical, or maybe a family member or an accountant or CPA. Someone comes in and they're able to manage the assets. And that could be after death or just during an incapacity event for temporary purpose. But the idea here is you don't want your heirs, especially in a death situation,
Right.
to receive all these assets all at once, right? So you might want to structure it over time. It's an extension of parenting for a lot of married couples, right? They can't be there to limit and provide an allowance, so they have a successor trustee listed, and that person will be able to do that for them.
And you hear the words revocable and irrevocable
Yes.
trust. What's the difference?
This is a big distinction on both a tax front and just a mechanics front. And the type of trust we've been describing is a revocable trust, which means you can change it at any time. It's a grantor trust for tax purposes, and that allows you a lot of flexibility. So you can change it, you can shut it down, you could do anything that you want to do with it. And because of that, it doesn't provide a lot of creditor protection. Irrevocable trusts are used to provide for creditor protection. You cannot change them. You have to have a separate trustee, right? This gets into elder law with Medicaid planning. Also, if you have a whole life insurance policy, putting that in an irrevocable trust or an ILIC can get it out of your taxable estate. So it's more a sense of permanency versus the ability to change it and the different results that ensue from those different types of trusts.
Let me ask you something, because I heard it on the radio today. They were talking about, public radio station, they were talking about how there's a scam going on where people are petitioning the court in order to get the, what do you want to say, the power
Yes.
over some people, and the people aren't even aware of it.
Yeah, so if you're a creditor, let's say you're a credit card company, and no one's administered the estate. So someone passes away in Massachusetts owing credit card debt. The credit card company actually has a right to the debt that's owed to them. So they'll actually go in and serve as that trusted role of the personal representative or executor, and they'll be allowed to actually advance that and try and get paid out of it.
Right.
So I don't know if it's a scam, but it's probably these companies trying to collect a debt.
No, this was more a scam in terms of they'd go petition the court, say these
Okay.
people are not competent.
Oh, I see.
And then sell their house, put them in a nursing home or assisted living facility.
Yeah, so just the vulnerable population taking advantage of the elderly. Oh, I'm the trusted friend of this person. Oh, they're losing their capacity. Yeah, I could see abuse of power there happening. The court is really designed to prevent that from occurring, but if they don't have anyone else speaking on their behalf, or a medical professional or something like that, I could see them being taken advantage of. I wish I had heard that spot. It sounds interesting.
It was. So in a situation like that, they would call you?
Well, in a situation like that, the hope is that they've done an estate plan in advance, and they actually nominate someone through these documents saying who their guardian or conservator would be. We use those two terms in Massachusetts, that would be able to take care of themselves and then also their money.
Right, I see, okay.
Yeah.
And then an estate, how would you define it, an estate?
So an estate is simply the sum of your property or things that you're entitled to, right? So the plan itself takes those assets into consideration. And even if you don't have a lot, it's really important to decide who's going to receive things. We have cases that are over, not a lot of money, but it's over, mom's painting that she made. The actual value, the monetary value is low,
I see.
but the sentimental value is high.
Yeah.
So if we don't identify, if mom doesn't say, I want my daughter to receive this, or I want my son and daughter to share this, and every year they trade off, or some sort of a scheme like that, it causes a lot of family conflict, and that can be very costly to litigate because all those matters are on an hourly basis for attorneys.
Right, gotcha. So I know you had given me 4 categories in terms of reasons why someone should plan their
Right.
estate. Maybe you could run through those?
Of course, at a high level, organizational reasons, and this gets at some of the things we're talking about.
Right.
You really want to be clear about what you want to have happen with your assets, right? And that clarity prevents conflict later, okay? Then there's the financial reasons. Financial management, for one. If you go into the hospital for a period of time and you need someone to be able to pay the mortgage, you need your financial life continues whether you can actually function it or not.
Right.
So appointing someone to take over by using a trust is very helpful. And you can take that power back once you regain your ability to do so. Also, to be able to save on taxes, which we also talked about. So estate taxes,
How does,
being tax efficient.
Just how does that work? How would you be
So
saving?
by virtue of creating a credit shelter bypass trust, right, with 2 different buckets, it's called a Q-tip trust if you want to Google it. We do a mass Q-tip and a federal, in case you have a federal estate. And what it really does is it segregates certain money into these different buckets. And the benefit is really accrued at the second spouse's death. And this is only for married couples. There's other techniques for single individuals to be able to lower their overall taxable amount that's in their estate, but married couples are able to take advantage of this bypass trust. And this is a common technique, not in all states, but Massachusetts, it does work here because we do have a state-estate tax here.
So you have to be aware not just of the laws and the changes in the laws, but all the tax codes. And
Absolutely.
everything.
And this is a real concern, and I'm glad you brought that up, because there's a lot of people that dabble in this area. You might have a family law practitioner that's primarily doing divorce work, and they might have a will or a trust that a friend had, or maybe came in through, they see these documents, and I've even seen, attorneys cutting and pasting people's names in and not appropriately keyed to them, and it's an absolute disaster. And so we much prefer to do proactive lawyering the right way, get it set up, in the right way in the beginning.
Right.
But we do the litigation and sort of the cleanup crew work as well. So we sort of be able to catch it on both sides, and we're able to do that. But there are a lot of people that probably shouldn't be doing the trust work especially, and they do. I also know a lot of attorneys that say, I'll do a basic will for a client, but if it's a trust matter, which it is for most people if you own a home, they're doing a referral to another firm.
Right. So in your opinion, do you think that everybody should be owning their home in a trust?
Yeah, just for the benefits we've described, the management benefits, the ability to have it not be tied up in probate for a year, the ability to decide who's going to receive it after, if you're a married couple, you and your spouse, obviously the spouse is the first person that would receive it, or if they don't actually have full title to it by virtue of joint ownership. But you're able to dictate what's going to happen with that property. So it's a significant asset you want to take care of. And when you're buying, it's a great time to do it.
Great.
Yeah.
Okay, and then you gave a couple other reasons.
Sure. Health reasons. This is something that's often not discussed a lot because everyone's focused on the money. But we spend a lot of time with our clients on the health reasons for doing a health care proxy, giving someone the authority to act on your behalf. The ability to do a living will, which although it's not legally binding, can't take someone into court and say, hey, you didn't do what I wanted.
Right.
It's very helpful to that healthcare agent. What that document does is it lays out, I would want this medical procedure, I would not want this. It really gives them control. And it also alleviates the decision makers' sort of guilt or anxiety about what would mom want, right?
Yeah.
And especially among married couples. Most people aren't sitting on the couch with a glass of wine saying, all right, so if there's no reasonable likelihood that you're going to come out of this coma or have an event like that, what would you want to do? Would you want to have the quote-unquote plug pulled? Would you want to wait a certain period of time? Maybe you'd want to be on a breathing machine but not receive, artificial nutrition. People have very specific desires when it comes to this, and it's often not articulated. So this is an opportunity to do that.
Was it you who had said to me that college students also
Yes.
should have this?
So the other document included under healthcare is the HIPAA authorization. HIPAA is a federal privacy law to protect your medical records. And as soon as you turn 18, you're an adult. And so, parents wouldn't be able to receive medical information, on their own child because they're adults, right? Unless that child does an authorization. Most hospitals have these documents, but people rarely do them unless they're going in for a procedure or something like that. So we make sure that all of our clients that have anyone over 18, they're going to get those documents as well, so they can make decisions for their children if the children choose them, of course, as those decision makers.
Yeah, but no one ever thinks of this.
Absolutely, even married couples.
Yeah.
Because you walk into the hospital and you say, "I'm the husband," and your wife's in the hospital or your husband's in the hospital. I'm the spouse. Well, how do you prove it? You might have the same address, you might have the same last name, but they don't know if you got divorced last week and then you've got a ex-spouse really pulling the plug on something, right? So the hospitals here are very concerned about that. So the easiest way to assure that is to have a validly executed healthcare proxy, and that's a basic component of a basic plan that we would do.
And what happens? Do you bring these actual papers to the
So
hospital?
some people do. Some people leave it with their primary care and they put it in their sort of medical records in advance.
see.
We provide electronic copies of these documents, of
Right.
course. So we help facilitate that information collection phase on behalf of the medical provider at the end of every state we do.
Great. And then, of course, there's the emotional reasons
Absolutely.
for planning an estate.
Yeah, I mean, like I said, you don't want, oftentimes there's a matriarch or a patriarch, and when they pass away, people fight, and the people are grieving and going through all sorts of transformations emotionally. And so if you have a very organized estate plan, not only would it save money, but it will also really save the stress and anxiety of deciding what would this person have wanted, or who's to receive money. It makes things clear, so it prevents arguing.
Gotcha. So, in trusts, and I had asked you, did you think everybody should have their property in a trust?
Yes.
Yeah. Maybe you could go over some of the other reasons.
Sure. There's a couple different, trusts that you could have. Especially, we'll focus on real estate, right?
Yeah.
So one of the types of trusts that we do for people is an irrevocable Medicaid trust to place certain assets if they're going to be applying for and needing that care in the future. There's a 5-year look-back period. And that's sort
Can
of
you explain a little more about that?
I can, but I don't think we have enough time to go into it fully. And it's definitely an area of law that's changing quickly, but it is something that people do. The idea there is, long-term care planning and the sort of health needs at the end of life are a very significant financial burden, right? So there's certain planning you can do involving a trust, and it may or may not involve putting a piece of real estate in that trust to protect it for the future generations, right?
Yeah.
You may have a great like heirloom property, something you want to pass down to the kids, the cabin up in Winnipesaukee or the Cape House, and you want to sort of keep it there and maintain it. A trust is a good vehicle for that, to be able to pass it intergenerationally, okay? The other thing that you can use for trusts is just something that's fallen out of vogue a little bit, but a nominee realty trust. The utility of those is fairly limited, but some people that just don't want to know who the owner is, right? You can have a separate schedule of beneficiaries and keep that separate. So you might see some of those. They're very popular in the 80s, less so now because a subpoena can just find out who those beneficiaries are if you actually get into litigation. But that's another type of trust you might see out there. So if someone says they need a real estate trust, that might not be the case. They might do one of the different ones we've also been describing. But for most married couples, they're going to want to put their home in that trust and actually occasionally split the value between the two to be tax efficient.
Gotcha. So, is there a big difference in terms of states? I mean, if you have a trust in Massachusetts or New York or New Hampshire?
Yeah, yes, there is. But with the trust, you can key that trust to a certain state's law that you want. And also you can have a provision in there to actually change what's called the situs of the trust to get different results. It's a little bit more technical probably than you were looking for an answer, but yes, you can do that. And if you move here from a different state, it's a great idea to have those documents reviewed because a lot of other states they're not as concerned about the state estate tax, and here you're going to be concerned about that. So that's a great opportunity to review documents. Also the healthcare docs. Yeah, they should work if you did them elsewhere, but you don't want to have the hospital kick it up to their legal department to review. It's much better to just have a recent validly executed Massachusetts healthcare proxy, for example, to be able to provide, and it's a smooth transition.
Great. Okay. So you've also talked about LLCs
Yes.
as a structure to purchase real estate.
Right.
I know when we're talking often, you keep touting the benefits.
Well,
of
of
it,
course, yeah. I mean, a lot of people, they do great on their own. They, with a single property, they really like being a homeowner. And then to make more money, they look to maybe getting an investment property. And they might buy something and fix it up and rent it out. And they might do this again. Maybe they have 2 or 3. it grows. So we find that the people that really enjoy real estate like that, they tend to do this and grow it. The problem is that each time they have a property they're renting out, there's a lot of liability associated with that. So by putting each property in an LLC, it's usually a flat fee, very inexpensive to do. The one kicker is the fees that the Secretary of State charges, $500 a year. But by doing that, you're actually segregating that as an asset away from your own property.
Right.
So it's creating these barriers, these walls, which you want to do, and you
So
want
it's mainly for income-producing properties?
Yeah, mainly for income-producing properties, because there can be some tax consequences if you're both living in it and renting it out.
Right.
Which again, we would need more time for that. But if you're renting out property, it's definitely worth looking at whether or not to place that in an LLC or another entity type, in order to limit your liability. It's all about limiting liability in case something exceeds insurance.
So you said that people can always find out who's in charge. Can they sue you if you have an LLC?
Yeah, they can, but they'd actually sue. So you, being the LLC and the sort of manager of the LLC, they'd sue the business, which is the LLC,
Right.
and that would keep your assets separate. It creates additional barrier. You can't stop someone from suing you, right? But you can easily remove you individually from that claim if you have a corporate structure and you've done all the necessary formalities and it's up to date. That's the benefit of it. You're limiting your liability. And really, it is a business, so it really should be in a business form.
Yeah, I get you. Right. So you want to give us your package and
Sure, yeah.
what's contained, because obviously there's a lot to cover.
There is.
I'm
And
sure
always,
you have it.
whenever hiring a lawyer,
Yeah.
how much is it going to cost, right? The classic thing, right? So we try and eliminate a lot of that by just being upfront about pricing.
Right.
And this on the screen here, we've got a married couple estate plan. Just as sort of a basic idea, this is lower than some other people in the Boston area for sure, and it's a little bit more expensive than someone that's just doing a basic will, but you're getting a lot more. It's a lot of documents, and we do this on a flat fee, so it's anywhere from $2,500 to $3,500 for really 2 estate plans, right? Because a married couple, we're doing a separate set of documents for each one of them,
Right.
And that's a flat fee that you pay, and then you're done. There's really no additional fees to it.
And what happens to these documents? Do the people take them home? Do you keep
Great
them?
question, and lawyers do this, they treat this all different. I'll tell you what my firm does. I know it's a little bit unusual, but we offer to keep those documents in our firm vault free of charge for as long as you want, on the idea that we're invested in the relationship, and if there's an issue with them, they should be able to come to us, or if one of their children says mom and dad are in the hospital, there's an accident, we can be the provider, that nexus, that quarterback.
Right.
But that's our philosophy. I know a lot of firms don't do that. It's not the norm. I know that there's some people charge subscription plans. Any edits and document storage for X amount a year. And a lot of lawyers just hand it back over to the couple. We don't like that because people lose those documents.
Absolutely.
And there's not a lot of follow-up. One criticism of people in this area that do what I do, they don't make sure the trust gets funded. I bet there's a whole bunch of people out there that say, oh, they did an estate plan. Great. Did you fund the actual trust? Did you transfer assets into it? That's often where
That's
a
what
lot
you
of
mean by funding.
exactly
Transfer
just the transfer of assets from your own name, even things like the bank accounts, all those things, retirement assets. These are really important things that a lot of other attorneys that we've seen, at least when they come in with reviewing documents, that work hasn't been done.
Right.
So I'm not sure why, but we make it a big priority for our clients.
Right. So when you say you store these documents, are these stored electronically, or
well,
you actually physically store them?
Well, we both. So we store certain documents, especially the will needs to be an original, right? So we store the original documents. We provide the clients with a printed set in a binder organized with summaries so they know what they are, but those are just copies. And we also store the documents electronically. The physical ones are stored in our fireproof, locked vault at the firm. And so the idea is we are taking on custody of those, and anytime anyone wants them, they're welcome to have them back.
Right.
But we just think it's an important component to this working later.
Right.
Because the idea is you set this up now, and hopefully you don't have to use this for many, many years.
Yeah, hopefully.
Right.
Right. So this is all, in effect, disaster or post-death planning, in a sense.
Yeah, disaster in the sense that you could have an incapacity event, sure. I just think of it as being a responsible individual, honestly. I know that's people don't think about this, but you're pre-planning desired results so that it's cost effective for your family,
Right.
saves on legal fees, is tax effective,
Right.
okay, and also doesn't cause fighting, which is a really important concern.
Right. Well, certainly just for the peace of mind alone,
Exactly.
it's
my
worth
favorite
it.
part of it, absolutely.
Right.
When people sign and they get that sense of relief. Because, once we educate people on this, education is the biggest thing. People don't really know how much they need these documents, right? So once we get over that hurdle of education and they're able to sign these documents, they feel at ease because they actually know that their family is taken care of. It's going to be cost effective. It's going to work for them. It's going to be what they want. Their intent is on the page. You don't have to do these proclamations at the dinner table or at reunions. Oh, I want this. You know, in the U.S. American system, in the legal system, it needs to be on page.
Right.
Okay. So
I hear you. So can you summarize the difference between what you do and someone like Andy Schwartz, who was on the show,
Sure.
who's a real estate attorney with Cummings, Crowley and Cummings? So.
Right. So he may be able to do things like those, like the real estate trust I mentioned, and he may even have a practice that involves some estate work. But ultimately, you know, most real estate attorneys are on the transactional side. They're making sure that you're able to purchase that home, that the closing goes well, that all the documentation's in place, you know, legally representing you, you know, fighting for you if you want certain provisions, you know, all the sort of things that you initially probably discuss with the clients. You know, he's on the side of making it happen legally, the transaction of the sale.
Right.
He's also probably responsible for getting them title insurance and things like that.
Yep.
You know, we're more, where he leaves off, we pick up. And what we're doing there is not just dealing with the real estate itself, although that's a primary component for most people's plan. We're dealing with all their different assets, and are they working with a financial advisor, you know, all those other things, sort of issue spotting for them and getting them organized, because the estate plan is really the foundation of the family's financial, you know, structure. And then who they work with and what assets, those all change all the time. But these documents is the infrastructure that we're putting in place.
Great. So I have to ask this question because I have to. Do you yourself have an estate and trust?
Absolutely. So I know a lot of attorneys that do what I do and they haven't gotten to it, and it's sort of the, you know, the cobbler's shoes are always in disrepair sort of thing, but no, I absolutely have one. It's very important.
You do?
Yeah.
Okay. Well, we have a couple minutes, so I'm just wondering if you could give an example of how an estate plan, a trust, helped one of your clients.
I can do that. You know, the obvious things are that it's saving people taxes, it's saving people money, it's avoiding conflict. What I really would prefer to answer is just a really sad example of where someone didn't have it, the basics,
Yep.
and the result that ensued under the intestate law. So a lot of people don't realize this, but in Massachusetts, if you're married but you don't have any children, the entire estate might not go to your spouse.
Why is that?
Because of a statute. So the legislature has decided that it's a certain percentage of your estate that goes, and then anything exceeds that would actually go to the decedent's parents. And that's if you don't have a will.
Right.
So we had a case where it was a local service provider for one of the municipalities, and they had a wife who passed away, you know, while working out, younger, you know, under 50.
Wow.
And we had to basically contact this person's father who had been out of the picture. You know, there was no real relationship between the decedent and the father who was living out of state, but we had to send a check out of state. You know, it didn't go to the hands of the husband because of the default law.
I see.
And a simple will would have avoided all of that,
I
right?
see. So-
In the most obvious case, beyond something like that, you know, it just is really, it hits the wallet hard, right? So it's very cost efficient to have a plan like this. And it's like anything. You spend a little bit of money now, and you save a lot on the back end.
Right.
Yes.
So how can people get in touch with you if they have questions or they want to have an estate plan done?
Well, you know, I always tell people, you know, open door policy, if you will, you know, through email. You know, my firm is Long Night, Huff, Harrison, Hagen, and we're at longnightwithak.com. My contact information is on there. You can call the firm. You know, we do consultations all the time, and we really try and help people. So if you do have a question, you can also email me directly at hagen@longnight.com, and that's HAGAN@LONGKNIGHT.com.
Sean, thank you so much. This has been great. You were so informative, and I have to call you.
Absolutely.
I have to get my estate
Thank you so
done.
much for having me.
All right.
It was fun. Thank
Yeah.
you.